Good morning. Happy St. Patrick's Day. Or at least I'm told it's St. Patrick's Day. I hope you're wearing green. And if you're not wearing green, I hope you're nowhere near Earl or any of the other child and sexual molesting auditors, rapists. We got quite a few, it seems. We need to call the pest exterminator or something to get rid of all these cockroaches. Anyway, apparently in about an hour, Minnesota Guardian, I don't know, little 18-year-old kid is going to premiere a video about postal inspectors showing up at his door. To which all I have to say is, congratulations, kid. You have federal law enforcement showing up at your door when you're 18. You are on the federal law enforcement's radar. Your life is not going to be fun. I'm not saying it's too late, but your life is not going to be fun. You had postal inspectors showing up at your door. There's an investigation going on. Maybe they were investigating the actions of the other guy, or maybe that's what they said, but I'm not entirely sure. From my understanding, Minnesota Guardian has been trespassed from multiple post offices. He's been disruptive in multiple post offices. They may be looking for the book so that they could throw it at him. Let's talk about hearsay. Hearsay is an out-of-court statement that's being asserted in court for the truth of the statement. So it's something that was said out of court that you're saying in court to show the truth of what is stated. Bobby said he loved me. Bobby said he loved me would be probably a hearsay statement. Because Bobby's not on the stand, I'm on the stand. And I am asserting that Bobby said he loved me. Now, I might be asserting it for something other than the truth of the matter. I could be asserting it for the effect on the listener or a variety of other things, but generally speaking, you get what I'm saying. Bobby said he paid $3.50 for those shoes. Things like that. Now, there are lots of exceptions or exclusions depending on if it's the federal rule of evidence or your local state, or your state's rules of evidence. But one common thread is a statement by a party opponent is generally an exception or is excluded from the hearsay rules. And a statement by a party opponent, let's say that I sued Bobby and I get up on the stand and I said, Bobby said those shoes cost $350. That would not be hearsay because that's a statement by Bobby. He is a party opponent. I could get a witness on the stand and that witness could say, I heard Bobby say that those shoes cost $299. That's also not hearsay. Now, if Bobby gets on the stand, Bobby can say, well, I said that those shoes were $350 because he's there for cross-examination. It's not hearsay. But if Bobby called a witness and the witness said, I was there too and I heard Bobby say those shoes were $399, that would be hearsay because Bobby called the witness. And the witness isn't testifying to a statement by a party opponent. Bobby, the party opponent of Bobby is me. I'm the one suing Bobby. Now there are other hearsay exceptions, but that is the statement by a party opponent exception, or it's excluded from the hearsay rule in some fashion. And what Earl did last night, and in all of his videos and appearing on other shows, is he's giving the prosecution a ton of ammunition. If Earl gets up and testifies, then they have a bunch of statements that he's made out of court where they can attempt to impeach him, or they could just, even if he doesn't get up on the stand, they could just use that stuff. You know, this is what this guy thinks. This is how he thinks it. This guy said this back in 2013. He said this in 2015. He said this in 2017. And then in 2019, he said this. His story's changed on these things because he has talked about Deer Park and his daughters. He's talked about him before. He keeps talking about him. If Earl brings his character into evidence, which I doubt his lawyer would do, considering that he is a multiple felon and a convicted rapist. I don't think Earl should want to bring his character into evidence, but if they do, then the prosecution can just go ham and impeach his character evidence all day, every day. There will be so much character evidence against him. They'll show him to be a liar. They will just rape his face with past statements, all of which are admissible, provided they're relevant. I mean, there may be some relevancy issues. There may be some, more prejudicial than probative issues, et cetera, et cetera. But I mean, generally speaking, he has given the prosecution a wealth of data to screw him with. And he's not smart enough to realize it. I've been asked multiple times, do I think that Earl's attorney would allow him to do what Earl's doing? I don't think Earl's attorney has the power to stop Earl. Earl's a full-grown man. Earl can make his own mistakes. I am not in contact with his attorney. Where are you going? Come on. I'm not in contact with Earl's attorney, nor do I want to be. But I would assume that if Earl's attorney is even the slightest bit competent, Earl's attorney would have told Earl to shut the fuck up and stay off social media till all this is done. Now that's really hard on Earl because, of course, Earl makes his money on social media. So Earl's between a bit of a rock and a hard place. And if you don't want to get between that rock and a hard place yourself in your personal life, don't rape your daughters. That is a bit of legal advice I will give you right here, right now, no matter what state you're in, no matter what country you're in, no matter what planet you're on, don't rape your daughters. And I think life will proceed much more smoothly for you. It's amazing how many non-daughter rapers can go on to lead productive and happy lives. He's innocent until he's proven guilty, right? In the justice system, that is correct. He cannot be punished. He must be presumed innocent by the jury, etc. I'm not the jury. I am not a citizen of Texas in the county that he's being tried in. So I am not now, nor will I ever be on his jury. So I get to say that I firmly believe he did it. I can't prove he did it, obviously, and there's a chance he didn't, but I think he did. Anyway, last but not least, I'm just having a hell of a time listening to all this stupid. There's so much stupid. I tried to listen to the Black Label stream. He was streaming from his Discord. It's funny how once upon a time Black Label didn't want to stream from Discord because the quality was bad or something like that, and it's better on a phone call. But now he's absolutely fine streaming from Discord. It's amazing. He'll take his content where he can get it. There's just so much stupid. I just want to address a real quick point. Someone, I don't know who it was, sounded a lot like Maximillionaire, but I could be wrong. someone was saying that in order for speech to be protected by the First Amendment, it has to be communicative. And that's just flat out wrong. I think it was Turner v. Driver. If not Turner v. Driver, it was another one of those you can film the police cases that spoke about photography. And the beauty of photography is you may not intend to communicate anything when you're taking the pictures. And yet it's not until after the pictures are developed, and maybe even years later, that you realize the significance of what you took a picture of. And at that point, you may wish to communicate that picture. You take a picture and all of a sudden you realize that you caught the assassin of JFK in the picture, right? Now all of a sudden that picture is worth something. Now all of a sudden that picture has value beyond your personal whatever you took it for. The court recognized that. And the court specifically said that just taking a photograph is protected speech, whether you intend at that time to communicate that to other people or not. At the point you take that picture, it is protected speech. And there are other examples too. I mean, burning a flag. It's a lot of it comes down to your intention. Burning a flag is communicative speech. It is protected speech. If you're intending to show like your displeasure with the government or something like that, whether or not you communicate that idea, it comes down to your intent. I intended to do this as a protest. Standing on a street corner holding a candle, not saying anything, can be communicative speech. If your intention is to protest something or bring attention to something or whatever, as long as your intention is there, that's all the court needs. So there's just a lot of stupid going on. I don't know why someone who's anti-government and pro-free speech would try to put that stupid limit on speech when the courts themselves haven't placed it there. Anyway, I got a busy day again today. I might not be on at 4 on my Discord for questions and answers today. I'm just super busy, lots to do. More things to do than time to do it. But I will try. I will make an effort. And if it works out, then I'll be there for anybody who wants to debate or argue or ask questions or whatever. Thanks for watching. Have a great day.